So welcome everyone to our NLRB update for Virginia LERA. We're so happy that all of you are here with us today, and we are very fortunate to have with us Sean Marshall, who's the Director of Region 5 of the NLRB. I do know that all of you are probably well aware of the changes that have been occurring at the board in recent years as the board has switched from majority Democratic to majority Republican and back. There have been a lot of changes. That's not the way the board was many years ago, but that seems to be what's happening these days. So there's a lot going on, a lot of changes occurring, and Sean Marshall is the perfect person to let us know about that. His region covers most of Virginia, and he has wide expertise at the board as well as in private practice. Before he joined the board, he's been both a staff counsel to an NLRB board member, and then has worked in the region in a number of positions, and now is the head of the Baltimore regional office. So I'm going to turn it over to Sean. We will save time at the end for questions, and if folks have questions, feel free to put them in the chat, or when Sean finishes his remarks, you can also raise your hand and I will recognize you to ask a question. So I will turn it over to you, Sean. Thank you so much.
Thank you. And thank you for that very kind introduction. It's very nice to see some Region 5 alums here. Hello, Stephen. Hello, Christy. Go Birds. And thanks for the Virginia LERA for inviting me to speak today. And it's a real pleasure. Unfortunately, I'm appearing to you from Baltimore as opposed to last year, when I was appearing to you from Virginia. But you do get the benefit of probably a little bit more refined and thought out presentation than your Maryland chapter got, which was 2 weeks ago. But what I wanted to start with, just to give you a lay of the land of how I'm going to proceed here, is first subject is going to be what has already happened. The board cases that have come out at the end of Member John Ring's term in mid-December that I think are really noteworthy for practitioners to be cognizant of, just to speak about some of those cases. Next is where we are right now. And where we are right now are the areas in which the board has issued invitations for public comment in a number of important legal areas that I think are worth discussing. So I think those are definitely areas in which you want, and folks on both sides of the bar and labor relations should be cognizant of issues pending before the board, in which I think that you can legitimately expect to see some activity probably before the end of August of this year. Next is the area of rulemaking, which I'll talk about briefly in terms of the board's notice of proposed rulemaking that have come out on 2 subjects. And finally, some of the general counsel issues, which I think that you should be cognizant of. Those include some of the memorandum that the general counsel, Jennifer Abruzzo, has issued, as well as some of the positions that she has taken before the board in pending litigation right now, as well as some of the other issues in which I think that you can legitimately expect to see some activity in the future. And as Ann said, we'll certainly save plenty of time at the end for questions. One caveat, which I'm sure you're cognizant of, I'm not going to discuss any matters pending before Region 5. If anybody wants to call me and yell at me afterwards, 410-962-2785. So start with the new precedent. As many of you know, the board is composed of 5 seats. All 5 seats were filled as recently as I think December 16th, 2022. One of those seats was vacated with the expiration of board member John Ring's term. Member Ring was a Republican in terms of the board tradition, and the expiration of his term, as you got to the end of it, you started to see some of the more significant precedent coming out. Some of which I think can justifiably be characterized as the pendulum swinging back to the way that a Democratic era, Democratic majority board is going to view the law. So in other words, the Republican majority under then Chairman Ring swung one way from the prior Obama era board, and now you see the pendulum swinging back under a Democratic majority board under Chairman McFerrin. I think probably, in my opinion, the most significant of these pendulum swings that came back to a Democratic era timeframe involves bargaining units and the board standard for evaluating the appropriate bargaining unit in a representation case petition. The board, towards the end of Member Ring's term, announced that it was returning to its prior specialty healthcare standard for evaluating petition for bargaining units. So what the board will now be looking at, which is what they had been looking at previously under the prior Democratic majority, is the petition for a unit comprised of a readily identifiable group of employees? Do those group of employees share a community of interest? If you meet that, an employer who wishes to add employees to the unit in order to make it appropriate, according to the employer's argument, would need to demonstrate an overwhelming community of interest of the employees it seeks to include in order for them to be included in that unit. So the case was American Steel Construction, and that overruled the Republican era board case of PCC Structurals. Second topic was employee access to properties of employers other than the entity that employs those employees. And this involved Bexar 2, Bexar Center for the Performing Arts. And in doing so, what the board did was return to its prior standard, again from the Democratic era board, from New York, which was a case involving a casino. In Bexar 1, the Chairman Ring board held that employees of a contractor that works on a property can only access that property if they regularly work on site and if there's no other reasonable way for them to engage in some sort of protest or other protected concerted activity. Returning now to the New York standard, a property owner can only lawfully exclude employees of a contractor that works on site for them to perform protected concerted activity if it would significantly interfere with the business operation or there is some other legitimate business reason for excluding those employees of a contractor. Pendulum swings the other way. I think that these are areas in which I think that you can legitimately expect, if and when the board composition changes again, to be areas which are possible to swing the other way, but they have swung now back to the Democratic majority board. Third is a case involving employee ability to wear some form of union insignia. And the board case that is now the current law involves Tesla. And what the board did in Tesla was announce really the presumptive right of employees to wear and display union insignia. That's presumptively unlawful absent some sort of special circumstance that would justify any form of restriction on their ability to display or wear union insignia. That reversed a Republican era decision called Walmart Stores, which held that the special circumstances test only held when an employer completely banned all form of union insignia. The last area in which I think that you can really point that as the pendulum swinging the other way involves employers ceasing dues checkoff contributions after the expiration of a collective bargaining agreement. Now, this was an area of law which had existed for quite some time. The board in Bethlehem Steel in 1962 had identified that at the expiration of a collective bargaining agreement, the employer could unilaterally cease dues checkoff. The board reversed that in, I believe, 2015 in a case called Lincoln Lutheran, calling this was an unlawful unilateral action on the part of the employer when they would cease this dues checkoff. In other words, that survived the contract, and any change to that post-contract expiration was an unlawful unilateral change, absent agreement or an overall impasse. Republican era board in Valley Hospital took it back to the Bethlehem Steel standard, but now in the same case, Valley Hospital 2, similar to Bexar 1, Bexar 2. Now you have Valley Hospital 1, Valley Hospital 2. They've now reinstated that it is unlawful for an employer to cease dues checkoff contributions at the expiration of a collective bargaining agreement. The second to last area in which I think the board made a major legal position towards the end of Member Ring's term was a case in which, frankly, my personal opinion was it was a curious decision on the part of the board to issue a public comment period regarding the standard under which an employer can lawfully interview employees as part of an unfair labor practice defense. For those of you practitioners, this is commonly known as Johnny's Poultry. In my opinion, Johnny's Poultry was not exactly an area of law that was in much controversy. So it was somewhat unusual when I think, for me, when you saw the board inviting public comment on that. What the board did was uphold the Johnny's Poultry standard. So for those of you who are not familiar, what this requires when an employer is preparing a defense for an unfair labor practice proceeding and they want to interview an employee as part of their defense, they need to satisfy certain criteria. One, they need to communicate the purpose of the questioning. Two, they need to assure the employee that there's not going to be any reprisal and that their participation is voluntary. Three, the questioning has to occur in a context free of anti-union animus, and the questioning itself must be non-coercive. And fourth, the questioning needs to be limited to the legitimate purpose. In other words, you can't go into other matters or inquire into the subjective mindset of the employee. So those are three areas in which I think you saw the pendulum swing the other way, one in which the board has held and reaffirmed longstanding precedent. But the most consequential, in my opinion, decision that came out prior to the end of Member Ring's term is, ironically enough, a case that deals with consequential damages. That case is Thrive, THRYV, for those of you not familiar with it. What the board held firmly in Thrive is that its make-whole remedy for discriminatees, victims of unfair labor practices, those discriminatees should be compensated for all, quote, direct and foreseeable pecuniary harms resulting from those unfair labor practices. In other words, what we would refer to in the field as consequential damages. Now, typically, you would seek back pay as well as reinstatement for an employee that was unlawfully discharged. But the concept of consequential damages goes beyond that to such things as, for example, has the employee incurred an additional charge for being unable to meet a credit card payment? That's just one example of a possible consequential damage. Now, the board articulated in Thrive where this would be litigated, whether or not certain economic harms were a direct and foreseeable pecuniary harm, would be litigated at the compliance proceeding. So for those of you very familiar with the board's processes, you litigate a case initially before an ALJ. If there's any sort of appeal, that goes directly to the National Labor Relations Board. Board issues its order. That needs to be something that's enforced by a court of appeal. The remedial stage, the compliance with the board order or court order would become subsequent. And if there's any controversy about what constitutes compliance, that gets litigated in a separate compliance specification proceeding. Now, for those of you who have experienced cases in which we've been seeking consequential economic damages, that's something where, as a part of identifying a discriminatee and their consequential damages, that's going to be something that's proposed to you prior to the issuance of a complaint. So it's something where, from the general counsel perspective, we are investigating and making at least some initial determinations about those consequential damages prior to even the issuance of a complaint, because there would be damages that we would be seeking as part of the initial settlement proposal. Now, consequences can occur, obviously, as time continues on. So just something that you should be cognizant of in terms of us seeking it initially, but it being litigated later. So those are the things that have already happened. Here's the things that I think you can completely and justifiably expect will happen. And by timeline, I think that you can expect things to happen prior to the end of August 2023. And I identify that date because that's the next time when a board member seat is expiring. The board member seat is occupied by Gwen Wilcox. That's scheduled to expire towards the end of August 2023. I'm not a prognosticator. I'm not going to guess when or if President Biden will nominate or renominate anyone. What I can tell you is just the facts that member Wilcox's seat is scheduled to expire at the end of August. And by operation of tradition, the board oftentimes likes to get resolution in all cases in which a member is participating prior to the end of that member's term. So here are the areas in which the board has invited public comment. First is the board standard for determining independent contractor versus employee. And again, this is a pendulum swing type of issue. The case in which the board invited public comment involves Atlanta Opera. The current standard for independent contractor versus employee status is Super Shuttle DFW. Again, a Republican era case, which was styled as a return to the traditional test for independent contractor versus employee status. That overruled FedEx home delivery. That common law test that was involved was the common law agency test, with the burden on the party asserting independent contractor status. FedEx took a slightly different view of that common law test. And what it did, in my opinion, was take a look at what the actual entrepreneurial opportunities were for the purported employee/independent contractor and evaluated any constraints on those individuals' entrepreneurial opportunities in order to make a decision as to whether the individual was a statutory employee or an independent contractor. A couple other areas in which the board has invited public comment, one of which comes up very, very frequently in terms of charges, has always come up very frequently in terms of charges in my time with the region, covers the legal standard for evaluating employer work rules. The case in which the board has invited public comment is Stericycle, and that goes to really what the current standard is for evaluating employer work rules. The Republican era board case that dominates this landscape is a case called Boeing, and it set up a kind of multi-step inquiry as to how employer rules would be evaluated, identifying laws that were, or rules that were presumptively lawful, presumptively unlawful, and then how you look at the rules that fell in the middle ground. That Boeing test was refined in a case called LA Specialty Produce. What's, I think, lurking in the background is the prior case in which employer work rules were evaluated, which curiously was a Republican era case from a prior Republican administration involving Lincoln Lutheran Heritage, which set up a fairly straightforward framework as to evaluate rules that did not directly implicate Section 7 activity or explicitly restrict Section 7 activity. And I think Lincoln Lutheran Heritage could be boiled down to the most common type of scenario would be whether a reasonable employee would view that rule as restricting Section 7 protected activity. So I think what you're looking at now is the likelihood of the board probably returning to something more like Lincoln Lutheran Heritage. But what the board's invitation for public comment also involved was certain very, very specific rules. What the board had done was identify those rules as presumptively lawful. These were regarding rules such as confidentiality regarding pending investigations, non-disparagement clauses, prohibitions on outside employment. Can people still hear me? My screen went blank. Now
we can still hear you, but this is interesting.
Yeah, the screen is weird, but can hear you fine.
You can hear me fine? This is like an MC Escher.
It looks like.
Yes, we can hear you.
Okay, well, I'll keep going. I won't worry about this. The third area in which the board has invited public comment are regarding confidentiality requirements in mandatory arbitration agreements, and whether those confidentiality requirements in arbitration agreements, whether they in and of themselves violate Section 8A1. That's are the major areas in which the board has invited public comment outside of its rulemaking. For its rulemaking, they really fall into two distinct areas. One concerns representation cases, and the board has issued a proposed rule regarding the fair choice and employee voice rule. This covers really is a response and a pendulum swing back from rules that were implemented during the prior Republican administration. I think the biggest aspect of these rules, and really what they would do, is they would rescind the rules that were implemented under the prior board. The biggest area, I think the most impactful area, would be rescinding the rule regarding the blocking charge policy. As many of you know, it's a common thing when there is a pending petition, oftentimes a decertification petition, for a unfair labor practice charge to be filed, which previously would potentially block the further processing of that petition. So what this rule would do, it would rescind the current rule, which allows those elections to continue proceeding despite a pending ULP charge. In a lot of these situations, we're proceeding to an election, but we are blocked from issuing kind of that final step, the certification of results. But we would still be conducting the election, sometimes impounding the ballots. What this rule would also do is, that would also go back to the prior standard of having some sort of voluntary recognition bar. Okay, the Republican era rule allowed challenges of statuses to voluntarily recognize unions based on a showing of some sort of majority status at a prior time than it would be permitted now. That would what the proposed rule would do was go back to the prior law of there being some sort of voluntary recognition bar that existed. The Republican era rule also allowed for certain elections in limited settings involving construction industry employers and employees, where there was certain collective bargaining agreement language that converted that status to the standard status for collective bargaining representatives, also known as 9A. So the proposed rule would restore the old blocking charge policy, recognize that voluntary recognition bar, and take the construction industry employer and employee cases back to where it had been, such as the recognition of, for those of you who speak the language, the Stanton Fuel language in collective bargaining agreements. The other big area of proposed rulemaking is joint employer status. What the board's proposed rule would look at is whether the purported joint employers share or co-determine essential job terms, and where one of the parties only has sort of a reserve or indirect control over those essential terms and conditions of employment. The current rule requires direct and immediate control over essential terms and conditions of employment in order to satisfy the joint employer standard. It would go back to the prior rule, of which I think is styled as more in line with common law, as only requiring indirect or reserved control, not necessarily the actual exercise, an immediate exercise of control over terms and conditions of employment. Like I said, in terms of the composition of the board, you do have a Democrat in Gwen Wilcox, whose term is going to be expiring at the end of August. So I think in terms of looking at where we can legitimately expect to see some activity from rules, cases, et cetera, is that timeline as you approach the end of August, absent some sort of activity from the White House and the Senate regarding nominations and confirmations. So the last area in which I wanted to talk about was the General Counsel. And as many of you know, one of the first actions of a General Counsel when they come in is to issue their list of mandatory submissions to the Division of Advice. For those of you who are not familiar, the Division of Advice in headquarters, I characterize it as the General Counsel's personal think tank, policy shop. So when a new General Counsel comes in, one of their first actions is to issue a mandatory submission list of cases or issues to the Division of Advice in order to have a consistent national perspective and approach to the cases and arguments that the General Counsel will be offering before an administrative law judge and then to the board. General Counsel Jennifer Abruzzo was no different in this regard. Her mandatory submission memo is 2104. It involves a lengthy series of important issues and cases, types of cases, in which she's taking an interest, in which she directed regions to submit to the Division of Advice. So if you're looking for all of the policy initiatives, that's really the best place to find it. Some of those cases have already involved specific positions that the General Counsel has taken in other memorandum. More importantly, specific positions that the General Counsel has taken in positions before the board. Those cases in which I mentioned, in which the board reversed prior precedent, those were cases in which the General Counsel has advanced a position. There are other cases that are currently pending before the board in which the General Counsel has advanced positions advocating for the reversal or modification of existing law. Before I talk about some of those, I do want to highlight three specific General Counsel memos beyond 2104 for things in which I think there's a very clear articulation of a General Counsel viewpoint that such conduct would violate the National Labor Relations Act. The first of those came very shortly after 2104 was issued, and that's 2108. And all of these are available on the agency's website. 2108 discussed the classification of, for lack of a better phrase, student athletes at colleges and universities. The position that General Counsel articulated in 2108, among others, was that she potentially viewed a college or university's classification of individuals as student athletes as potentially violative of the act in and of itself, because the notion would be that you were misclassifying these employees as something other than employees and coercing and restraining their exercise of Section 7 rights by characterizing them as student athletes. The second memo in which I wanted to identify a really clear legal position taken by the General Counsel involves GC 2204. This is the memo that covered the General Counsel's position on captive audience meetings or other sort of mandatory meetings. It wouldn't be fair to simply characterize this memo as applying exclusively to what we commonly refer to as captive audience meetings, in which an employer gathers its employees on work time to present some form of presentation advocating for employees to reject union representation. The memo discussed other situations that would not necessarily be considered as what practitioners on both sides of the bar would consider to be captive audience meetings. It could be something as small in terms of the number of individuals involved as a supervisor approaching an employee on work time in the workplace and having a discussion with that employee advocating for employee rejecting union representation. In 2204, the General Counsel identified such issues as mandatory submissions and that regions should plead such instances as violations of 8A1. The third memo that I wanted to also specifically mention was a more recent memo, 2302. This memo dealt with electronic monitoring and surveillance. Again, I think it's important to actually read these memos thoroughly and carefully in order to discern some of the important details that I think can be missed if you're just looking at the title, the first paragraph. In this memo, the General Counsel identified a notion that it's unlawful for an employer to use certain algorithms or electronic monitoring in order to restrain, coerce Section 7 activity. But the memo went beyond that, and I think it's fair to characterize things as electronic monitoring, that we might necessarily think of electronic monitoring in the common parlance. something as simple as a video system that covers areas of the workplace, including the break room, that's something that the general counsel might consider as violative of section 8A1. So those are three memos that I think it's worthwhile taking a look at. General counsel position on some other issues that I think everybody should be cognizant of. One involves a fairly old area of law that's known by its case name, and that's Joy Silk. Joy Silk is the case that stands for the proposition, as we know it now, that an employer may be required to recognize a union without an election, without an NLRB conducted election, where that union claims to represent a majority of employees in an appropriate unit, and where the employer cannot show a legitimate good faith doubt as to those employees' wishes for collective bargaining representation. The corollary to that would be that the general counsel would view it as a violation of 8A5 for the employer to fail to recognize and bargain with just such a union. So the concept is Joy Silk. The general counsel has taken a position on the issue, and I think that you can legitimately expect to see some sort of board comment on that at some point in time in the future. Already mentioned the aspect of captive audience meetings. That's a case in which the general counsel has actually taken a position for the reversal of fairly old board law involving Babcock and Wilcox. It's funny how the same names often come up in these contexts of NLRB law. Another big area in which the general counsel has taken a position involves a type of case involving what we refer to as an excello case. And that's not a case in which you're dealing with whether something is lawful or unlawful. Excello really deals with what is the remedy. Excello covers the remedy in bad faith bargaining cases when employees have been denied of the opportunity to enjoy the benefits of collective bargaining. The general counsel has already taken a position for the board on this type of issue, but as you can probably expect, this can come up in a number of different circumstances. And probably the situation that's best tailored to this is the initial bargaining and the test of cert case, the situations in which an employer tests the board's certification of a union as the employee's collective bargaining representative. A couple other areas in which I think you should really be aware of that the general counsel has taken a position before the board, in which I think you should legitimately expect to see some activity. General counsel's taken the position that an ALJ is wrong to approve a unilateral consent order, such as at the outset of a hearing, over both the objections of the general counsel and the charging party, where the remedy is less than what would be considered a full remedy for the alleged unfair labor practices, as well as containing a non-admissions clause. And as some of you know, the aspect of non-admissions clauses is a particular area of importance to this general counsel. In Region 5, I can say that we routinely do not allow non-admissions clauses in settlement agreements anymore, consistent with the general counsel's view. But what this position that the general counsel has taken before the board is that when there is a resolution, it should involve a full remedy for the unfair labor practices. A couple other areas in which the general counsel has taken a position. One is overruling Raytheon, which is a Republican-era board decision, and it's holding that an employer may make changes after the expiration of a collective bargaining agreement to employees' terms and conditions of employment, where those changes are consistent with past practices that had been encompassed in a now expired management rights clause. So Republican-era board said those changes, as long as they were consistent with past practice, are lawful. General counsel position is no, those should be considered unlawful unilateral changes. General counsel has also taken the position of overruling board law on what constitutes a gift or a bonus of some kind that's not directly related to employees' terms and conditions of employment, but that such should be considered part of wages for which there's a bargaining obligation. For instance, I'll use a very, very rudimentary example. Thanksgiving turkeys. Employer gives all of its employees Thanksgiving turkeys. An employer's change to that or further gift on that subject very well may involve a bargaining obligation, and their maintenance or cessation might also involve an unfair labor practice charge under the view of the current general counsel. Last few, overruling the standard for an employer unilateral changes. This is a significant one. As many of you probably know, the board, the agency, and the DC Circuit have long involved themselves in a discussion over what standard to apply, whether it was a quote unquote contract coverage standard, which the DC Circuit preferred, or the clear and unmistakable waiver, which was the longstanding standard of the board. Under the Republican era board, the board changed that standard to go with the DC Circuit's contract coverage type of analysis. So in other words, as long as the contract covered the subject, an employer's unilateral change may not violate the act. Whereas clear and unmistakable waiver, that would look to see whether the subject involved a clear and unmistakable waiver, and unless it did, an employer's unilateral change, unless otherwise privileged, very well may violate the act. The Republican era board case was MV. The general counsel has urged the board to overrule it. Also urged the board to overrule General Motors, which was the standard where the board shifted to a standard for evaluating all type of adverse actions under a consistent standard. That overruled a case involving Atlantic Steel, which was the standard by which the board used to evaluate cases in which an employee who had been engaged in protected activity does something and potentially loses the protection of the act. Under the Republican era board, the board did away with that question of losing the protection of the act and simply evaluated all of those cases under the consistent right line standard. The general counsel has urged overruling that to go back to the Atlantic Steel situation in which you're evaluating whether or not an employee has lost protection of the act. Some of the more long-standing disputes in which the general counsel has taken a position involving a case called Allstate, which the Republican era board issued, and I think made it more difficult to ascertain when an employee is engaged in protected concerted activity. The general counsel has urged the board to overrule Allstate. Also urged the board to overrule two cases that dealt with the evidentiary showing of animus whenever there was an adverse action involved, such as an adverse action that was alleged to be because of an employee's union activity or their protected concerted activity. The Republican era board in two cases, one in which is the case that nobody knows how to pronounce, I'll just call it Shigfree, and the much more easy to pronounce Electrolux. The general counsel has urged overruling those cases to return to the more traditional right line scenario case in which you're looking at a significantly, I think, wider range of circumstantial evidence to prove animus. And lastly, the general counsel has taken the position of evaluating the more dry dock standards for the types of secondary object cases, which come up very, very infrequently, but involve some significant potential damages on the part of the union. Last area in which the general counsel has taken a position, or the position is very clear, is reversing a board law called hot shops and the employer's ability to permanently replace economic strikers. The general counsel would take the position that such is unlawful and that an employer does not have the ability to permanently replace economic strikers. So I've covered quite a lot. It's an ambitious agenda that the general counsel has. I'm sure you've seen 2104. It's a fairly lengthy document, lengthier than most of the mandatory submissions. But I think what you saw is not a lot of activity at the end of the member ring term. Some cases that I think reversed some Trump era board precedent, but not as many as I think some practitioners were expecting. I think that you can legitimately expect to see, quite a bit of activity before August of this year. And certainly the general counsel has advanced a number of arguments overturning board precedent or establishing new board law. I wanted to leave plenty of time for questions. Again, not going to discuss any pending Region 5 matters. If anybody wants to call me afterwards to talk about a Region 5 matter, my telephone number is 410-962-2785.
Thank you very much, Sean. We really appreciate that enlightening presentation and all sorts of stuff going on, as folks can tell from that. So we'll open it up now for questions. You should feel free if you want to type your question in the chat. I'll be happy to ask Sean, or if you simply want to raise your hand, there's an electronic way to raise your hand, or if you're on screen and just wait. Well, I can't see everybody on screen, so you probably should electronically raise your hand and I will call on you if you want to ask it directly. So I see one comment here already. Some news headlines from Justin that Congress had increased the NLRB budget. How do those changes affect the region's work and how the region processes cases and deals with parties?
Sure thing. I'll do my best to answer this question. And keep in mind, I mean, folks, obviously, as I'm sure you know, there's stuff I can tell you and there's stuff I can't. I'll probably go a little bit over into the stuff I can't. And if I do, I'm sorry. We did receive an increase of approximately $25 million to our budget. However, 20 million roughly of that, my understanding is 20 million was really simply to maintain our status quo where we are in terms of increased employee salaries as well as the rents that we have. So $20 million was really of that 25, so 80% was really necessary for us simply to keep doing what we had been doing. That remaining 5 million, I think that you can legitimately expect to see some limited hiring, even though I do not presently have any sort of hiring authorization. I anticipate the possibility of getting some in the relatively near future, but no current hiring authorization. But also I think that what you can legitimately expect that excess to go to is, number one, I think hiring is a priority. Two, we have certain technological needs that we need to maintain and upkeep. So I don't think that it changes the region's processes and cases and how we deal with parties. What I would hope for is to have a little bit more staff so that we can have our caseload for agents be something a little bit less than what it currently is right now.
Great, thanks. Other questions from folks? Well, I'm not seeing one right now, so let me ask a question.
Absolutely.
I'm curious about the caseload of the board in the regions. Like, what are you seeing in terms of caseload increasing, decreasing? Are there particular types of cases that you're seeing more of or less of? So if you could comment on that, that would be great.
Sure. Well, there has definitely been an increase in the agency's caseload. There's been a marked increase in the number of unfair labor practice filings, as well as a more significant increase in the number of representation case filings. In Region 5, I haven't actually looked at our statistics in terms of where we are with our unfair labor practice case filings. But I can definitely tell a notable increase in terms of the representation case filings. And where we've seen an increase in the representation case filings are directions in which we hadn't really seen much activity previously. The big ticket items, so to speak, in that regard are the number of petitions that we saw for individual Starbucks locations. And in the wake of that, perhaps precipitated by that, we've also seen an increase in the number of, again, single facility petitioned for units in other retail areas. Those retail areas might be coffee shops. Those retail areas might also be other retail locations like bookstores. Another big area in which I think the political environment and the composition of the board is more favorable for representation case filing cover graduate students. And we just recently held an election for the graduate students at Johns Hopkins University, which was the largest unit that we had held an election for in quite some time. I think the unit was approximately 3,200 employees.
Wow, that's interesting. Have you also seen any sort of rise in charges relating to collective bargaining or bad faith refusals to bargain?
I think our charge filing in that regard has stayed fairly consistent. I mean, we're very fortunate in Region 5, and I'll say the same thing to the Virginia LERA that I said to the Maryland LERA, is like, I think we're very much blessed in Region 5 to have a mature bar on both sides of the equation that knows their responsibility is really to deal with each other and not with me. And my job is to facilitate that. So in terms of the charge filings, I don't think we've seen an increase, at least from what I've observed, in terms of the bad faith bargaining. Where you see some activity are I think in response to the general counsel initiatives. In other words, general counsel identifies something either in the mandatory submission list or some other aspect of general counsel communications, and then we see some activity that comes on the heels of that, such as Excello remedies. And again, I do want to commend the members of the bar on both sides for being cognizant of that, and also being cognizant of that involving some of those issues is by necessity going to slow down the processing of a case. So to the extent that you're not interested in utilizing your case as an Excello vehicle, identifying for us that you're not interested in that type of remedy, and to be cognizant of what's the best way to approach your particular case. So I think that you've seen some activity that's, I think, precipitated by general counsel initiatives, but largely I think it's been pretty consistent from my observation.
So I think what you're saying is that those cases that have been identified as mandatory advice cases are going to go to advice, and it's going to take much longer to get a decision on those cases with respect to whether or not you're issuing a complaint. Am I understanding you correctly?
Well, I think it's similar to that. I wouldn't characterize it as necessarily much longer. It's just going to be longer because by nature there's going to be an additional step involved of whereas I'm not rendering a decision and either dismissing a case or issuing a complaint, but instead I'm sending something to somebody else for somebody else to work on, and then they return it to me. By nature, that's going to inject some time in the process. Sometimes it's short, sometimes it's longer.
I see a hand from John Barr. John?
Hi, Sean. This is John Barr, and I apologize for not having my camera on, but I'm very scruffy right now, so it would not be helpful to anybody. And I do really appreciate
you'll get no argument from me.
You have a tie on. That's like one of the and I do really appreciate your coming in. I tend to represent employers. I also teach labor law periodically. I've taken over a little bit from Ann at the University of Virginia. And one question, like I taught the course last semester, and one question that kind of came up from students that I couldn't really respond to it, and just want to see if maybe you'd have a good response, is from the point of view of my clients, understandably, and the board's going to do what the board's going to do, it drives them crazy. Like, okay, it's legal. Now it's not legal. Wait, it's legal again. Now it's not legal. And they just want to comply with the law.
Sure.
And I appreciate you got to enforce the law with what the board says, but could you, any sort of like, okay, employers, here's how you can kind of hedge your bets, or here's how you can kind of protect yourself. If the law does radically change, radically might be too much of a word, but if the law changes significantly, depending on the composition of the board, here's something you might be able to do.
Yeah, that's a tough that's a tough question to answer. I think what you would want to do, and what I would want to do if they were my clients, what I would want to do is I would reduce the number of issues that are potentially in play down to as minimal as possible. In other words, if you're presented with a situation that has 3 potential NLRA issues, 2 of which are really not in dispute as to what the legal standard would be, but one of which is, I would advise my client to eliminate those two. Make sure that you are in 100% compliance with the state of law, because that area of law is not in dispute. It's this other area that's in dispute. And I mean, just kind of talking out loud, I think an area in which the general counsel had identified in terms of the mandatory submissions list, I think, what were the situations, and again, we'll talk in terms of the pendulum swing back and forth, is the notion of pre-decisional bargaining over discretionary discipline in the context of a newly certified union pre-CBA. You know, that's something where right now, current law is that an employer doesn't have an obligation to engage in any sort of bargaining with the union, newly certified union, when there's no CBA. They have post-implementation bargaining obligation, but they don't have a pre-implementation under current law. But you know that that's something that the general counsel is going to take a position, if she hasn't already. I don't think she has, but it's identified in the mandatory submissions list. That's the type of thing where, yes, current law says this, but you know, if you do it, there's a real possibility that you're going to see a complaint, even though it's consistent with current law. But if it's just that one issue, I think where you're talking about current law versus general counsel position, if it's only one issue, I think there's a possibility that where it's only one issue, you would still see a dismissal.
Okay, great.
Of
Thank
an
you so
unfair labor
much.
practice charge. Yep.
Yeah, great. Thanks so much. I appreciate it.
Not in every circumstance. I think there's a possibility that you could see a
Sure.
dismissal.
Sure.
Okay, I see another question here in the chat from Christy. Can you talk a little bit about how the NLRB, the region, is currently handling in-person appearances versus remote options for investigations, hearings, and elections?
I prefer them. I mean, I'll work backwards. For elections, the gold standard is in person versus mail ballot. Obviously, the pandemic had injected a different element into that that was beyond the San Diego gas and electric factors, and that still exists, but it exists to, I think, a lesser extent. The gold standard has always been in-person elections. Hearings, that's really something where that's up to the judge, and that's consistently the position that I've taken in the kind of the outset of the pandemic. When I was issuing complaints and notices of hearing, I was not directing the hearings to be held virtually. That's up to the judge. I feel comfortable saying our position is where it makes sense to have something to be conducted remotely, then that's something that we should evaluate whether or not to conduct it remotely. But where it makes more sense to have it in person, we should be conducting it in person. Colloquially, I would say that in terms of hearings, there are, I think, advantages to be gained from conducting certain hearings remotely. But one disadvantage is, and my kind of casual observation is, hearings take longer remotely than they do in person. I think in-person hearings, they have a momentum to try to finish. Remote hearings, I think they have the absolute opposite of a momentum to finish. You see more breaks. There are more breaks in, I think, the continuance of a hearing. In other words, if a hearing opens on Monday, we might not necessarily resume on Tuesday. In person, I think there's a much higher likelihood that you're just going to continue through to the conclusion of a hearing in person. Investigations, the way we've handled that is based on the nature of the allegation. The more high impact allegations, those are the affidavits that we're going to want to be taking in person. The closer the witness availability, those are all considerations in terms of making the virtual versus in person. But for the higher impact cases, those are affidavits that we're going to want to take in person.
Great, thanks, Sean. Well, we're almost
problem.
at the end of our time here. So I want to thank Sean very much for making this presentation. It's been incredibly informative for everyone, I think, and it's always really helpful for those folks who practice before the board to hear from the regional director and to learn about what's going on sort of inside the board, as well as the decisions and positions of the general counsel. So thank you so much.
No problem.
Thank all of you. Yeah,
Actually,
go
and
ahead.
I did have one other thing that I wanted to mention, and that's, these more sophisticated hot button issues, these issues of particular importance to the general counsel, something that might involve a change in board law. It's not just, I think, the division of advice, us going to the division of advice weighing in, that's going to inject some additional time in the process. That's going to happen at other stages of the proceeding. So I think that you can legitimately expect, if you're going to have one of those issues that comes up before the board, to expect the board to take longer with that type of issue, just because it's the nature of reversing law, changing law, modifying existing law. So I think that's something that all parties should be aware of, that it's going to be, additional time at multiple points in the process.
All right, great. Thank you. And thanks everyone for attending. Let me just tell you about a couple of upcoming presentations from Virginia LERA. We have a presentation on March the 9th that's called Advice from Arbitrators. Any of you who do arbitration, this will be a great presentation to attend, because you'll hear from arbitrators about presenting cases and do's and don'ts from the mouth of the arbitrator. So that'll be a terrific presentation on March 9th. And then on April 13th, we'll hear a presentation about organizational ombuds and how that works. And so I encourage you to go to our website and sign up for those presentations, and also encourage you to join Virginia LERA if you haven't. Again, you can do that on our website. Our dues are very reasonable, and we're excited to have folks from all across the spectrum: union, management, lawyers, non-lawyers, neutrals. We would be delighted for you all to join Virginia LERA. Somebody here asked for the website, so I will try to type that in for folks if I can quickly find it. And I think, Emily, is it LERA Web? Riley put it in there. Great, thank you. So there it is for folks who want to join or want to sign up for other presentations. And thank you all very much. And let me just remind our board members to stay on the link. So thanks, everyone.
Thank you. Thanks everybody for being here.
Thank you so much.